how do you sustain professionalism in an adversarial world? And to me, you have to start with looking at what professionalism is. It's defined in the rules of professional conduct, and a critical element of professionalism is this concept of zealous advocacy. How do we then interpret that obligation of zealous advocacy in a way that's going to sustain professionalism? I think one of the best starting places is to stand back and ask yourself, what is the ethical lens through which you interpret that obligation of professionalism, and particularly that obligation of zealous advocacy? The ethical lens is your own personal set of values, your beliefs, your own moral compass that helps determine the choices you make whenever you have to make a decision, strategically or in some other way. So some possible ethical lenses that can be useful. I think you can start with the most foundational one, which is do no harm. I think if, as professionals, we all maintain a strong sense of the mandate of do no harm, then a lot of ethical challenges or professionalism challenges can resolve themselves. Another ethical lens is to maintain the notion of yourself as a reflective practitioner and to think constantly about the context in which you're making choices. I felt that both Renu Mandane and Justice McLeod, they both referenced this in their comments. Being a reflective practitioner means being curious, relentlessly curious about things that are different, and, as well as being non-judging about all things that you encounter as a professional. If you maintain a sense of relentless curiosity about differences and non-judgmentalism about opposing counsel, about proposals on the table, about ideas being generated, what that allows you to do is dangerously consider new ideas. And it's that approach to being reflective that can help you manage effectively the kinds of dilemmas that will confront you when you're trying to conduct your practice in a professional way, given the fundamental adversarial environment that you're in. So negotiating in an adversarial world is challenging because you often don't know the approach that the other party is taking. As counsel, you can do all of your work, you can make a negotiation plan, you can identify your client's interests in advance and try and design a process that's going to address those concerns. You can't control the approach that the other side's going to take, and because we operate in an adversarial context, it may not be unusual for counsel to take different approaches, for one to be taking an interest-based approach and the other to be taking a very adversarial and positional approach. So that's one challenge right off the start is navigating how do we have that conversation about what approach we're each going to take to this negotiation, and seeing if we can agree on the approach that would actually be most productive for everybody to take. So a lot of counsel don't have a lot of negotiation training. I don't know that negotiation training is mandatory in law school, and certainly I think there are a lot of lawyers out there who haven't taken negotiation training and who aren't thinking through right from the very beginning, what's my negotiation strategy on this case? Is this a case where there are opportunities to explore creative solutions, to really explore the interests of the parties and to come up with opportunities for mutual gain? Or is this the kind of situation that really does require advocacy related to the law? So that's one of the challenges. I think the other challenge is for counsel everywhere to conduct a very realistic assessment of your client's alternative to a negotiated agreement and the other party's alternative to negotiated agreement. It's very, very challenging. And yet it's the critical first step in any negotiation planning. And I think it's a step that's often skipped. Certainly in my practice, it's probably the number one mistake I see lawyers making is they don't spend the time up front working with their clients to realistically assess what's going to happen if you don't reach a settlement here. What are your alternatives to getting a negotiated agreement? Should you negotiate? Are you better off going to court? Or is court absolutely the last place you want to be and your alternatives maybe don't look so great? An assessment of all of one's alternatives to a settlement is really the first step in designing a process, in advising a client on what they should do, what they shouldn't do, the point at which they should walk away, or how hard they should bargain. So I think those are two of the key challenges, and I think the third challenge would be lawyers aren't well trained often in exploring the things that drive the conflict in the first place. And some of the other speakers in this program have touched on this topic as well. So many times what's driving the conflict isn't a legal issue, and it isn't even often the issue that's on the table. It may be something far deeper, far more complex. It may be something historical. It may be something unspeakable. There's lots written out there about the core concerns that human beings have that they need to have acknowledged and addressed before they're going to really be able to resolve conflicts. And the legal system isn't designed to spend much time exploring these drivers of the conflict, these core human needs for acknowledgement, needs to have your status recognized or your role recognized. And yet if these core concerns aren't addressed, the negotiation may reach an impasse. It may get very adversarial. It may get very positional without anybody ever realizing why. The other main challenge is getting a clear understanding of negotiation power. In the family law context, this is easy in that it's built right into our process. We spend time up front with each person conducting a formal assessment of negotiation power in family mediation. So why do we do this? We do this because the research tells us that the cases that are least likely to settle are those where the negotiation power between the parties is significantly different. It means if you can spend time at the beginning analyzing not only actual negotiation power, but how each party perceives their negotiation power, because we know that often people either overestimate or underestimate their own power in the negotiation, and this very much influences how they conduct themselves. The more time lawyers can spend analyzing negotiation power before they start, the more likely they are to be able to take steps to try and create at least the perception of equivalent negotiation power. And I know this seems a little counterintuitive for counsel to be asking themselves, well, how do I need to empower the other party to perceive themselves to have no negotiation power or have more negotiation power? But in fact, it'll pay dividends because you're more likely then to have rational, focused dialogue when you can get the perception of unequal bargaining power off the table. I think one of the challenges that we all have in this field these days is there's a belief that interest-based negotiation is always the way to go, and that if you're bargaining hard or you're taking hard positions, that's unethical, and I think that's really wrong. Every case has the right process, and for counsel, the important thing is to accurately identify the right approach to the case, the one that's going to maximize gains for the client, and then communicate that. And communicate it in a very transparent and sincere way. I think the more open you are about, I'm taking an interest-based approach to this case, and this is why. I believe there's an opportunity to find joint gains. I feel if we take a really adversarial approach to this case, we're actually going to leave value on the table for the clients. By being really straight up about the approach you're taking in the negotiation, I think you enhance your reputation as a skilled negotiator and as a person who knows what they're doing. And it also is ethical. It's ethical and credible at the same time to be clear about the approach you're taking and why. There's no shame in taking one approach or the other, but it can lead to misunderstanding and frustration and even impasse when counsel are taking different approaches to the negotiation, and they haven't really identified that.